for a higher juicy news. Mema Obibia Akwaba. I had the latest hot nkwa enamede bramo. Anunti so we subscribe to channel dia bomodia share over subscribe. The over the share over click the subscribe button no. Na wa barely notification. We understand new video be upload no. When the first person what's ebeka sa video. Afi we are na wa like video no give us a thumbs up na fi share na or for so na when you be and share na wo and someone ekoso e wo Ghana memo adam afi yebura ye and someone ababeto yepono so mumaiti eye sankomo ya ababeto jai sansem yekoso mumaiti inti rekoso.
Is there a real challenge that this call for the review of these powers will solve? Kazo.
I think that we are faced with an issue that we should not confuse matters. What we are discussing this morning relates to a press conference by the minority leader. He calls himself the mighty minority leader. What that means, I don't know. But what is not in doubt is that the minority leader says that there is an unacceptable attempt by the NDC to infiltrate the judiciary, and now says that civil society groups must condemn that act. And not only that, he invites all other persons, religious leaders and what have you, to tell President Mahama to stop what the Constitution says he should do. Article 146 of the 1992 Constitution is in clear terms. Thankfully, our Supreme Court had the opportunity to interpret Article 146 on the removal processes, particularly as it relates to a Chief Justice. Question: has President John Dramani Mahama done anything today not stipulated by the 1992 Constitution? Certainly the answer is no. Now, President Mahama, having assumed the office of President of the Republic of Ghana on the 7th of January 2025, has received 3 petitions. The petitions are to the effect that, based on the constitutional arrangement, the only basis that you can remove the Chief Justice or a Justice of the Superior Court is 1, through stated misbehavior, incompetence, or infirmity. As I speak to you now, I have not had the benefit of seeing the content of the petition. I have not seen it. Because if you recall, the Supreme Court in Franka J. Chum had provided a certain parameter that the entire process should be kept in camera. Strict confidentiality. So President Mahama, guided by this decision of the Supreme Court, has kept the petition under wrap. In fact, if you recall, when Her Ladyship, the Chief Justice, wrote to him, however, copy to the Ghana Bar Association, Association of Judges and Magistrates, obviously the President expressed his disappointment with that conduct. Her Ladyship, the Chief Justice, demanded of the President, or requested, that Mr. President, I need 7 days to respond to these petitions before a prima facie case can be made against me. The President advised properly, said, yes, even your request for 7 days, I'll give you 10 days. That was offered her generously. Let the record reflect that Afenyo Markin, one of the principal advisors of Nana Addo Akufo Addo on legal matters, did not advise Akufo Addo to give Charlotte Osei the benefit of these 7 days or 10 days. That is our record. So it is a mark of, let me say, it is hypocritical, yes, for my leader senior Afenyo Markin to do a press conference and suggest that President Mahama is doing something untoward is regrettable.
Well, no, he's not the one who holds that. The argument by the immediate past Attorney General is that to the extent that this injunction application is being heard, it behoves on the president to halt any process ongoing under Article 146 until the determination of that case.
You see, as for Godfred, I won't even talk about him for now. Let me deal with a major issue. You see,
what is that? That underlines the position that Afenyo Markin has taken.
President Mahama's fidelity to the 1992 Constitution is something that should be celebrated. When he became president, he appointed a Shrad boss called Madame Vivian Loretta Lamptey.
Yes.
Now get something. Honorable Frank Anno Dompreh, MPP MP, and another gentleman by name Richard Nyama brought a petition to President Mahama that the Shrad boss so appointed by him has misconducted herself, financial issues, and therefore were seeking the removal of the Shrad boss. President John Dramani Mahama, consistent with his character to uphold the rule of law, accepted the petition, forwarded it to the CJ then. The CJ then made a prima facie determination, and the Shrad boss, Madame Loretta Lamptey, then
an appointee of President Mahama
was removed by President Mahama. Consistency. Today, as we speak, President John Dramani Mahama is in receipt of 3 petitions. I don't know the individuals. What has he done, having received these 3 petitions, to warrant that unprovoked, meritless provocation from Afenyo Markin? Has President Mahama done anything inconsistent with the 1992 Constitution? No. He received the petition. The Chief Justice said, President, I have become aware through a press release by your spokesperson, the Honorable Felix Kwachi, that these petitions are in your custody for my removal. Mr. President, before you make any comment further on this petition, Mr. President, I want to respond. The President said, well, I mean, that's fair. In fact, you should have actually spoken to me. Meanwhile, the letter requesting for it, you've copied other people. But that's beside the point. Your request is legitimate. I will give you 10 days to adequately prepare. Now, the President, having done this, was it consistent with the Constitution? Due process. He said, look, let everybody, you can't condemn a person without hearing, even though I differ. The President says, I will do that. Now the Council of State or whoever is supposed to go into the merit or otherwise of it. If the Council of State so advise the President and advise that he is not bound by though, what you do, if he sees that there is a determination of prima facie, you do a 7-member, a 5-member committee comprising 3 justices and 2 quote-unquote civilians to determine whether it merits your removal. In the meantime, the President has the power to suspend you. Now, from the time of the receipt of the petition to date, has President John Dramani Mahama done anything outside the strictures of the Constitution? No. Now, listen carefully.
I just want clarity. I'm told that there had been a ruling that says that if there is a petition against the Chief Justice, the President is not bound to give a copy of that petition.
No, so you see,
I'm just asking.
No, so you see, there were 2 schools of thought. That flowing from the Frank Ajechum decision. There is a lacuna. And that at this point, really, because personally, I think that when a petition comes and you respond copiously, it means that on the face of it, there is something that needs to be looked into. That's my view. And so I strongly believe that even at this point, the question of giving a copy to the person or respondent here, it's a bit, the Constitution itself is a bit silent on it.
Okay.
But President Mahama said, regardless,
Okay.
I will give you the opportunity, and gave her 10 days to respond. Now look at this. Afenyo Markin, who addressed the press, one of the principal legal advisors to Nana Addo Dankwa Akufo Addo until he left office, was here when Madame Charlotte Osei's petition came. Faceless individual. With all the issues, Madame Charlotte said through her lawyers, wrote to Mr. President Nana Addo Dankwa Akufo Addo for a copy of the petition to respond. Eugene Ahin, the presidential gongon beater, then said, listen carefully, then said, it is not in the place of President Nana Addo Dankwa Akufo Addo to give Charlotte Osei a copy of the petition. Mahama didn't say so. Mahama said, have it. Madam Sophia Akufo, then Chief Justice, because it relates to, did the prima facie determination. Eventually, the president appointed a 5-member committee. My Lord Justice Benning, the late Justice Mafusa, Agnes Doji, Abrampa, and another woman. They went into the merit and said, look, there is grounds, and recommended the removal of Madame Charlotte Osei. It was a 3-2 majority decision. You understand? So that is our record. Has President Mahama today done anything outside what Akufo Addo has done? In fact, he had even gone a step higher. The lawyer Akufo Addo was not willing to give a copy of the petition. The non-lawyer John Dramani Mahama respected the request of her ladyship, the Chief Justice, and offered her. She even requested for 7 days.
President Mahama. Don't compare President Mahama to Akufo.
Please, gentlemen.
Hold on.
I understand you are unconstitutionally interfering in the submission.
But I'm saying, if you compare,
So I am saying that. Wait. So I am saying that this attack from the minority, and I've heard my learned senior Darko and the minority leader, I see that Afenyo Markin cleverly wants to turn the conversation into an NDC MPP thing to muddy the waters. Cleverly. And if you heard my national chairman, he said, this matter, we are not talking about it, the merit or otherwise.
she speak.
President John Dramani Mahama has so far conducted himself so well. And it's also because he had the benefit of sound legal advice with the likes of the Attorney General, Marietta, and co. around him. They would not allow the president, even though a non-lawyer, to do anything outside the constitutional stipulation. And so, you see, I think that regardless of the merits of the petition, and I don't want to go into it, regardless of that, I have seen media houses, some other media houses and colleagues say, the NDC wants to remove Madame, what's her name, Chief Justice Torkonoo, because either than that, the NDC cannot do oral or something.
And that you don't trust the current architecture of the judiciary to prosecute the oral
Let me
cases.
tell you. I'll tell you. Hold on.
Shouldn't
No, I beg you. I'll give you a classic example. A case I conducted. So there is a judge.
I'm enjoying listening to you.
There is a judge. My Lord, I'll just use this example. And my Lord Justice Akabuafo, you know him?
Yes.
Okay. Good. My Lord Justice Akabuafo was appointed by President Mahama High Court. Then Nana Addo took him to the Court of Appeal. Right?
Yeah.
Good. So he strained both regimes. Correct. I did Ato Forson at the appeal before him as one of the Court of Appeal judges. When he saw merit in it, even though he was appointed by President Nana Addo to the Court of Appeal, he saw merit in our appeal and acquitted and discharged. So for me, the idea that, oh no, because you have been appointed, in fact, her ladyship Justice Torkonoo, do you know who took her to the Court of Appeal? Mm. Do you know who took her to the High Court? She strained all the political parties. Mm. So this has nothing to do with whether she was appointed by MPP or NDC. What we all need to do is soberly reflect, and I'm sure if a prima facie determination is made, we'll all have the benefit of knowing. Look, in the case of Charlotte Osei, and remember that when Charlotte Osei matter happened, Frank Ajechum had already been decided. As at the time, Nana Addo Kweku Addo forwarded the Charlotte Osei petition to her ladyship Chief Justice, I think so far Akufo, right? And she made a prima facie determination. What was it on? Procurement breaches. I remember at that time, I cautioned. I said, no. Superior Court judges, because of the countervailing force in our democratic experiment, right? The grounds for their removal should be something very serious. At that time, my friends in the MPP, my friends in the MPP said, no, it matters not. Procurement breaches is enough, and that constitutes stated misbehavior. I said, look, the Procurement Act itself envisaged the possibility of violation and provided in Section 90 the opportunity to rectify. Yes. And so, in the wisdom of the maker of the law, they envisaged a situation where there could be mistake. So they said, set up a committee, investigate the matters. If the committee now makes... So I was looking at a situation where before you can remove a judge, it should be on grounds that he has stolen public funds. There's some... Our friends in the MPP said no. And I remember, and I said this with so much sadness. Kweku Bako issued a writ at the Supreme Court. Yes. His lawyer was Samson Ladi Ayenene. That day, I happened to be at the Supreme Court with my senior Dr. Ayene on a different matter. That same day, the Charlotte Osei suit came, Kweku Bako's suit came up. His Lordship Justice Nana Megache asked Samson Ladi, Samson, are you saying that a breach of the Procurement Act is not a violation of a law, is not stated misbehavior? And that was it. That day, I left the court sad. I said, look, if we put it in that context, all of us become vulnerable. The level of vulnerability is high. But I think at that time, it was convenient for some people to do that. Possibly because it was Charlotte Osei. And I've always maintained that tomorrow is pregnant. The accounts have been saying, yes, oh, you are Fonsa. Now, why are they? Look, why is Afenyo Markin panicking? Does he have the benefit of the petition and its context?
Well, there's been some references made to some allegations that the minority purport to be in the petition, which they describe in words as frivolous. In fact, the current Swami Member of Parliament, John Darko, addressed the press this week, referencing some allegations purporting to be in the petitions against the Chief Justice, and the description given to those allegations that they are frivolous. I want us to take a listen to
so that I can come.
John Darko,
let's listen to John Darko. Then I can.
And then I will set the matters in context. Take a look.
We are told that a gentleman who committed contempt in facie curia and was thus accordingly punished by the courts was the CJ because he has been punished by the court, not the CJ. One of the last allegations we've heard, which is ridiculous, is the fact that the CJ has misappropriated some 75,000 Ghana cedis. An accusation which from the Judicial Service has been dealt with by the Auditor General's outfit. Justice Torkonoo's distraction should not be the grounds for your rising to the office of Chief Justice. To you, that judge, remember that you can rise together But if you ride on the distraction of somebody to write, remember that posterity will not be kind to you. To our development partners and foreign missions in the country.
So that's Jordan. Hold on, because this, by the process and details of Article 146, the details of the petition is supposed to be income right, secret. We shouldn't know.
So
but then again, the reference is made of the allegation.
My learned senior says we are told. Now, when the president had the benefit of the petition and the Chief Justice wrote the request, the president, in honoring the request, sealed the petition before giving it to her. Who informed the minority of the details? If Her Ladyship, the Chief Justice, in communication with the minority, because at this point, the petition is between the president and the Chief Justice. And in fact, for the president to guide the integrity of the process, he sealed, he marked the petition. I've heard one other journalist on Metro refer to what they claim to be the content of the petition. Who leaked to them? That is if it the details. No, but this one he phrases that we are told. Yes. Who told I listened to him carefully.
No, I just played that.
Who told him these contents? But you see, how come that he, John Darko, his own colleague, Afenyo Markin, Dompreh, brought a petition for the removal of Loretta Lamptey. President Mahama didn't say it was an MPP MP against my appointee. He received the petition, actioned it, he found merit, and dismissed his own appointee. How come that today, Anno Dompreh and his minority do not have confidence that President Mahama would do same thing he did to Loretta, affording her the opportunity to defend herself? Where is the fear? Where is the panic? You see, the stand of the minority relative to this broader national issue actually betrays a certain thing. It is extremely revealing. What is it? In all these constitutional arrangements, there's only one person under Article 146 to perform that role of receiving a petition. It is not Professor Ranford Jampo. It is not my learned friend here or this big man, not even me. Only president. The president. Who is the president of Ghana? Possibly the petitioner should have addressed it to the MPP minority before and given it to Afenyo Markin so that Afenyo Markin can consult the Council of State in this process. Malene Senior, you were called to the bar before me, and I've always been inspired by your legal work. What exactly is the complaint against John Mahama? My senior John Darko, what exactly is the complaint against President Mahama? Now, when you assume the position of now deciding that a petition is frivolous, are you not usurping the powers of President Mahama and the Council of State? Lawyer Darko, it is rather your conduct that is unconstitutional. It is rather your conduct that is unbecoming of a lawyer. President Mahama so far has only conducted himself within the confines of the law. Akufo Addo did it. The three commissioners of the Electoral Commission were all removed through that process. President Mahama has not invented a new rule. He's just basically holding fidelity to the 1992 Constitution. I think at this point, the minority must stay away and allow President Mahama to perform his constitutional responsibility. If there is any merit, and I've always said, thankfully, the Council of State has a retired Chief Justice on that committee. Her guidance, and in fact, thankfully, she even is in a very interesting situation. You know why?
Relationship.
No, Charlotte Osei's prima facie determination was made by who?
By her.
By her. So if there's anybody that has that experience, she'll bring that experience to bear. What did she see? In fact, if she's somebody who could make, yes, if she could make a prima facie determination for the removal of Charlotte Osei on her own, or even that one on her own, because remember that the process is different. If it comes to the Chief Justice, it's a different rule. But for other Superior Court judges, it's the Chief Justice that makes that determination. And she found it that in the case of Madame Charlotte Osei, the evidence of breaches of the Procurement Act was enough to warrant the establishment of the 5-member committee chaired by His Lordship Justice Benny. Has President Mahama done otherwise? No. So away from this, complete red herring. But it is actually an emotional conversation now. Because you see, CSOs, you must stand for the judiciary.
I'm here, I will speak.
Has President Mahama, as we speak, President Mahama, has he appointed any judge?
No.
Has he appointed any judge?
No.
So where from the interference? Has President Mahama asked that a particular judge should sit on a case involving him or his government? No. If there was any evidence of judicial interference, kindly look at the African peer review report in 2004. No, 2005. Even though it reflected 2004. When the Chikata trial, the fast track composition, where in the midst, President Akufo appointed Justice Afre to the Supreme Court and got onto the panel that reversed the original fast track decision. The African peer review mechanism report indicted the president as directly interfering in the judiciary. President John Dramani Mahama does not have that reckless record. So where is the conversation going?
Okay.
President Mahama, on the 7th day of January 2025, in taking his oath, said, I shall respect the 1992 Constitution. What Afenyo Markin and his micro minority are doing is to say, President Mahama, disobey the Constitution, which will now be a ground for his removal. Because remember that if the president disobeys the constitutional order, that's grounds for his removal.
Indeed.
At this point, with all the counsel available to President Mahama, he is fortified not to obey that recklessness, but to stick to what the Constitution says.
Right.
Let's see what the coming days will reflect.
Indeed, but lawyer Christian Mamhesi as well on this, because where is the concern really so far in the process as it's unfolding under 146, under Article 146? Where exactly does the position by, for instance, the immediate past Attorney General have merit that to the extent that there is an application for an injunction, the process should be put on hold until the determination of such a case before the process resumes to hear even the petitions against the Chief Justice and have that consultation with the Council of State? Where does that argument have merit?
Okay, all right. It refers to, there's this case that came before Akabuafo. J. Accident was now at the Court of Appeal, where the case is ex parte Mahama Bugri. And in that, he had to deal with an injunction application And in his ruling, he indicated that, amongst other things, where there are pending procedures of court, such that a ruling or judgment had not been given, and in such an injunctive application, especially when it has been served on the party has apprised himself to such proceedings as ongoing, then it requires on that particular person to hold on by actions that the person, hitherto that particular application being served on him or her, would have taken. Now, it meant that it is not only, and this relates to where injunction has been served and one is seeking to take steps and crossing into the line of usurping or interfering with the administration of justice. And it fringes into, it further fringes into issues of contempt.
Okay.
So it has to do with an injunction application served on the party where the application is yet to be taken, but the party carried actions so to overreach the court in respect of determining that particular application. So that was how this particular decision was borne out.
I see.
Yeah.
But, well, the concern is that if really... No, but Prof, I'll come to you. To the extent, let me stay with Lawyer Christian Mamhes in a bit. So, is that to say that with this injunction by that's Vincent Assefa and another at the Supreme Court, the expectation was that the President should halt the consultation with the Council of State on these petitions against the Chief Justice and asking for her removal?
It will, you see, legal jurisprudence helps the law. So that in this situation, where the actions of the President conjunctively with the Council of State, one is aggrieved by it, whether it is meritorious or not, out of which an application has been served. The jurisprudence behind it is that, just as I explained, in respect to this decision as reached by Akabuafo J, it means that, you see, and you will transpose that to section 10 of the Criminal Offences Act at 29. We also look at Article 1912 of the 1992 Constitution. That deals with fair hearing and also issues of interfering with justice administration or matters before the court. Now, the whole reason is that, and just as I said, when the application is served on you, you have to allow the court to determine it. At the end of the day, you seeking to carry out with a particular step has to be run in juxtaposition to what the court would say. And in determination of what the court would say, if it should go contrary to whatever step that you are taking, it will not run in sync with it. Now, if you take further steps, it would also be deemed as, just as I said, usurping the powers of the court. And to allow for the balance of rights of whatever the aggrieved situation or issues are, natural justice fair trial requires that allow the court to determine the application.
But I think let's be fair, counsel. You see, relief one of Assefua's suit. And always remember that an injunction doesn't stand alone.
Yes.
There's a primary document, which is the writ.
Yes.
Then the injunction is predicated on it.
Yeah.
Relief one of Assefua's destiny is that, to the extent that President Mahama did not notify Madam, her ladyship, the Chief Justice, prior to the consultation with the council, it was unconstitutional. Relief one.
That's true.
Now the president had gone ahead, not only notified her, submitted the petition to her for her comment.
That's
So
true.
the primary relief, hold on, the primary relief had effectively become what?
Moot. Nobody is arguing
So the issue of holding the balance has been taken care of.
Yes.
And you see, if you read the decision you premise, my Lord Justice Akabuafo's decision,
Yes.
you notice that he also gave a caveat that where the person is performing a constitutional duty, the court should be slow in clogging that constitutional duty with injunctions.
Okay.
In the same decision. So the judge then provides two scenarios. Oh, land, typical land issue. Oh, you are building on my land, there is litigation. Court can say, okay, hold on. Because you are building, stop. Let's get it done. But he said, look, once the person, and flowing from the decision in ex parte Ghana lotteries, he was fortified by that decision to say that once the person is performing a statutory or constitutional duty, the court should be slow in clogging that performance with injunctive orders, which finds expression in the decision that His Lordship Justice Akabuafo made. So he provided two scenarios. In this specific case, who else can receive a petition for the removal of a Chief Justice? The President. Who else will consult the Council of State? The President. So at this point, it is a duty that can only be performed by only him, not even the Vice President, not even the Speaker. So, Leonard, let's situate the conversation properly so that it doesn't look like the claim by Mr. Godfrey Adami. And for him, like I said, I didn't want to, because I did e-levy with him. Immediately the president assented. They started the collection, even though we were in court.
Okay, so that's why
I was in court that day with him, and he justified it.
So you say that
Incidentally, hold on. Incidentally, that panel, that e-levy panel, the leadership, the Chief Justice on it.
I see.
Yes.
So like
Look,
so based on the argument that you're making, to the extent that even there's precedence to what is happening now, the former President Akufo Addo was wrong to have assented to the e-levy, even though there was an injunction hearing ongoing or in place.
Yes, I mean, just as he said, you see, in the decision, the learned judge was even slow and cautious in making that particular decision. I mean, in response to issues of constitutional duties. You see, what is I love legal theory and jurisprudence a lot, because what is the philosophy of the law? At the end of the day, in the situation, we positing it in rule of law and looking at achieving justice at the end of the end goal is to achieve justice. Now, there is an ongoing process under Article 146. And with that process, Article 146 has been invoked. However meritorious or unmeritorious that particular application is, we all agree that that application has been rendered moot because the president has afforded her leadership the opportunity to respond. Now, for jurisprudence sake, what would it be for the president to allow that particular application to be heard in order to ensure that yes, rule of law has been upheld, and for whatever it is, even though in the Akabuafo decision, there was a caution by the courts to hasten slowly in dealing with constitutional matters. It did not, the decision did not serve as a bar, but it only indicated that when it comes to that, let's hasten slowly as to what the situation would be, or for further decisions to come, whether from the High Court or especially from the Supreme Court, to authoritatively declare on how matters involving constitutional matters should be dealt with. The situation would keep evolving. Now, in the milieu we find ourselves, one would say, or legal scholars would be split into two schools of thought, of should we allow, or should we say that where constitutional matters are involved in an injunction application is served, should the constitutional duties carry on, or there's a caution by a judge, by a learned judge, who indicated that yes, the constitutional duty is important because it is in respect of state duty. So let's hasten slowly. How do we deal with it? So these are matters of constitutional jurisprudence, and a clear decision ought to be taken to deal with such matters.
Because then anybody else will just go to court. And you see, for example,
I want to understand so that I can contribute.
So it's okay. Because you've made your point, I want to understand because it's okay.
Let me receive some. Edu's exposition on this matter bring some clarity. But when I listen to him, I get
allow me to just stay on the course of this matter. So, what exactly has President Muhammad done wrong exactly in this instance?
No, so in simple terms. In simple terms, an application for an injunction, simpliciter, when served on you, you have to restrain yourself. That is the legal thinking behind it. You have to restrain yourself from taking further steps until the matter is determined.
Despite what the judge said.
I'm building a point. I said an application for injunction simpliciter, when it is served on you, you have to restrain yourself, whether or not the matter is heard or not. So, pending the matter to be heard, you will restrain yourself. If the applicant can prove to the court that indeed there is proof of service of that particular application on you, you have been apprised with all that, and yet you took further steps with it, that particular person can bring a contempt application under the rules against you.
Catch the president.
Now, in the US, it is not far-fetched. I mean, where Donald Trump engaged in the deportation, it also deals with such injunctive applications. I'm giving you the broader legal thinking behind it, or the legal theory and jurisprudence behind it. And it is one that is espoused in the Commonwealth, and in such situation, the federal judge, Boagas, indicated that he could hold Trump's administration for contempt, for possible contempt, because they have further taken steps in dealing with the deportation of over 200 immigrants. Now, that said and put behind, the point is that, which I was building up, is that having said that applications or matters pending served on you, further steps ought to be restrained. In the same way, or by the same decision, the judge further went on to caution that when it comes to constitutional matters or constitutional duties, we have to hasten slowly.
So it is for winning a somewhere about better. Yapuno so make out say so we subscribe to channel idea, but more than say over subscribe. Now fee well like video don't give us a thumbs up. Now fee share my for so now when you be here now somewhere cause Ghana memoir. Also wait me atchere wadring afire and some way you comment box in mo. Mobeti in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.